Good afternoon, everyone, and thank you all for joining us for this Tenant Rights Listen and Learn. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. If you are unfamiliar with the format of this event, first we're going to watch an informational video on this area of the law. At the end of the video, we will have a question and answer session with one of our housing attorneys. You can put your questions in the Q&A box on Zoom or in the comments section on Facebook at any time. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and legal aid is not representing you. Please remember not to reveal personal details about yourself and to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to go ahead and start the video. If you have any issues with sound or anything, please put that in the chat boxes.
Hi, everybody. Welcome to the Tenant Talk. As Marissa said, this is general information about landlord-tenant law in North Carolina. I'm going to give lots of different examples of things, but at this point, this is just information for you guys to take. And when it's time to ask your questions, I can answer with general information to that as well, because again, I at this time am not anyone's attorney. I'm just giving you general information that hopefully will be helpful to you in your own case. Just a little bit about Legal Aid of North Carolina. We are a statewide nonprofit law firm, and we provide free legal services in lots of areas. You can see them listed here. I am a supervising attorney with our housing team. So that's what we're going to talk about today. You can check out our website if you do have other legal needs. So we're going to go over notices that you received prior to the eviction process. We're going to talk about the eviction process itself, landlord's responsibilities in terms of repairs, what your legal remedy or option might be in the event that the landlord does not make the repairs that they're supposed to. And then we're going to talk about how security deposits fit in to landlord-tenant law in North Carolina. And I might bounce around a little bit, but everything that we're going to cover is somewhere in these slides. And I'm probably going to cover it more than once. So starting with notices to vacate, I always like to begin this presentation emphasizing how important your written lease is. If you have a written lease, obviously you should read it in detail before signing it, but if it's something you have signed, chances are there's a lot of answers to your questions in there. Of course, a lot of it is legalese that is not totally easy to understand, but it is the most important document in terms of your housing situation, and it pretty much dictates how things are going to go, or how things need to go on both sides. And of course, we'll talk about what happens when you don't have a written lease as well, but just emphasizing the importance of looking at your lease and seeing what it says about your question. For example, if you have a written lease, it's going to explain, or most likely is going to explain, what kind of notice you are entitled to receive before an eviction is filed if the landlord's trying to file an eviction. And notice can be verbal, it can be in writing. It all depends on what your lease says is required. So if you do have a written lease, probably on that first page, it tells you what the landlord needs to tell you, whether in writing, usually in writing, and how much time the landlord needs to give you to vacate, pay, or whatever it is the landlord's trying to get you to do. If a notice is required, per the lease or per North Carolina law, before an eviction is filed and the landlord does not give you any notice or does not give you an accurate notice, then you likely or may have a defense to the eviction if it's filed in court. But again, the lease is going to tell, it's also going to tell you how much notice you have to give the landlord if you do not want to renew your lease. So all these things are in there. Again, if it's a written lease, most notices are required to be in writing, and they are required to say specific things and give you a specific time frame. Most of the time you are going to get a notice of some kind before an eviction process is started, but not necessarily. And we'll talk about the situations when no notice is required, even though you might think it is. Again, it's going to be in that lease. All right, so the eviction process. Again, the landlord has to, if you have a landlord-tenant relationship, meaning you have some agreement whereby you are able to stay somewhere in exchange for usually money, sometimes services, but usually money, then you have a landlord-tenant relationship. If you are to be dispossessed or kicked out of the home, the landlord can only do that legally through the eviction process through the court system. The landlord cannot say, well, you didn't pay, so I'm locking you out. They can try, but that would not be legal, and you would call legal aid if they did that. So again, the only entity that can legally kick you out of your home after you have a landlord-tenant relationship is the sheriff, and that is only with the approval of, or the order of a court and the approval of the clerk's office. Okay, so the eviction process is called summary ejectment. That's what the documents will say when you receive them from the sheriff. Again, you're only protected by the eviction process if you have a landlord-tenant relationship. If you are a guest, or if you're just staying somewhere without paying any rent, or otherwise don't have any sort of agreement, whether verbal or written, that you're allowed to stay at the home in exchange for a certain amount of money or a specific service you're providing, then you don't have a landlord-tenant relationship, and they are not required to file an eviction. They can just basically call the sheriff, or they can tell you to leave, and if you don't, they can call the sheriff and say that you are trespassing and need to be removed. But if you do have a landlord-tenant relationship, you are protected by this process, which means that they must file a complaint with the court, which of course comes with a summons. The summons is what tells you when and where the court hearing is going to be. The complaint, which is the page behind that, tells you specifically why they're trying to evict you, or at least it should tell you why they're trying to evict you. Typically, it is posted on the door or handed to you in person. It's also usually mailed. So they're the same things. You'll get a copy in the mail. This is going to be the same thing that's posted on your door. Or if you're home and the sheriff knocks and you answer it, then being served, that's called being served personally. It's when they hand it to you. And again, the summons is going to tell you when and where the court date is. The court of hearing is going to be in front of a magistrate, which is a pretty informal courtroom, kind of think like Judge Judy, but less drama. Well, sometimes less drama, sometimes more drama. But for the most part, it is an informal process, and it can move pretty quickly. Most important thing you should remember about this is that you need to be on time. If you're even 5 minutes late to an eviction hearing and you are not there, they are not going to say, oh, they're here now, let's hear the case. Once judgment for possession is granted, if you're not there, then it's granted. And then we'll talk about what your options are at that point. But make sure you show up on time, or even early in the event that you'd like to speak with your landlord or your landlord's agent or attorney. Just encourage you to get there on time or early. So there are 4 bases for an eviction: non-payment of rent, holdover, breach of lease, and criminal activity. I'm going to go over each one of those. This is the complaint in summary ejectment. So this is the eviction complaint. And this is what legal aid wants to see. If you're calling us, this is what we want to look at. We're circling these boxes here because this is kind of how we refer to evictions. You got a box 1, box 2, box 3, box 4. As you can see, those 4 boxes. And they are, in order, non-payment of rent, holdover, breach of lease, and of course, criminal activity is that last one there. That's going to tell you why the landlord is seeking possession of this rental property. So a tenant check is late. The landlord has made a clear demand for late rent, and the landlord has waited at least 10 days for the tenant to pay the amount owed before filing to evict. So a lot of tenants assume that they are entitled to this 10-day notice. And that's not necessarily the case, especially if you have a lease that looks like a form lease, like a long lease that looks, kind of generic. You may have signed a lease that waives the notice requirement, and we'll circle back to that. But in the event you don't have one of those leases that says those certain things, you are entitled to what we call a 10-day demand. So if you've got, if your rent's due on the 1st, it's the 7th and you haven't paid it, and again, we don't have one of those leases, the landlord has to say, look, you haven't paid your February rent, it's this amount, and you need to pay it within 10 days of today, or I'm going to file to evict. If that is what the landlord, if that's what the landlord has to do in this situation, then they cannot well, properly, file an eviction before those 10 days are up. For one, the notice has to say the right amount that is owed. It has to tell you the 10-day deadline, and the landlord has to wait till those 10 days are over to file the eviction. If you offer all of the rent that is owed in that time, they have to accept it. If they have to accept it. If they don't and file, then you would have a defense to the eviction. And essentially the way I think of this is if it's a box one, then they just want the money. They're not suing for possession. They're not saying, I just want the place back. They're saying, look, I just want the money. Which is why they have to give you this 10-day notice. They have to give you a chance to pay it. I just want the money. You have 10 days to pay it. If you have an oral lease, nothing has ever been put in writing, but there is an agreement on the amount, which is really all the agreement there has to be, then the landlord has to give you 10 days because that's what North Carolina law says. North Carolina has a law that sets in when a tenant does not have a written lease. So that kind of governs what's supposed to happen. So if it's an oral lease, North Carolina law is going to tell you what the landlord needs to do. And in this case, 10-day payment or 10-day demand for payment. If you pay it under those 10 days, great. If you don't, then the landlord can file an eviction for non-payment. However, keep in mind that if it is this box one process, non-payment, and you do offer to pay the rent at some point after that, or while the case is pending, they do have to accept if it's offered in full and you're paying court costs, and which we'll talk about a little bit later. So essentially, remember, if it's box one, your plan is to try to get the money together and offer it and document your offering it to the landlord if and when you're able to do that, because that's going to be important. So even if you don't have it by the small claims court date, but then you file an appeal and then you come up with the money while your appeal is pending, they have to accept it then too. We'll talk about the appeals later, but just remember it's all about the money with a box one. Okay, so holdover is basically just when the landlord says, okay, I'm not renewing your lease and I want you to leave now. You don't leave, then they have a right to file an eviction and ask for the judge to grant possession to you and then basically order you to leave. So this is really notice dependent here because you have to know what it is the landlord's asking you to do, or you have to understand what the landlord is trying to say. So if I have a 1-year lease and it ends, let's say it ends at the February, say it's from February to February, it ends on February 28th. It's a 1-year lease and it's in writing. And let's say I look at my lease and it says, okay, look, if they want me out of here before March 1, then I know that they need to give me at least 30 days notice. Again, this is just an example. A lot of written leases, those form leases do have 30-day notice requirements or sometimes 60 days. But so if that was the case and the tenancy was ending on February 28th, then sometime in January, well, why does it have to be February 28 days? Whatever, you get my point. If they have to tell you the month before it ends that they want you out by the end of the lease term, and they have to be clear about that so that you know what you're supposed to do before they file an eviction. Again, your written lease is going to tell you the notice period, and it's usually going to say it must be in writing and say certain things. If you have an oral lease, then again, we go to North Carolina statutes that tell you how much time must be given before an eviction is filed. So year-to-year lease, 30 days, month-to-month lease is only 7 days, and then a week-to-week lease is 2 days. That's pretty short notice. Month-to-month lease, we see a lot of these folks that are on a month-to-month lease and they get 7 days notice and are kind of shocked by how little that is, but that is, if you're on a month-to-month lease, be aware that at any of those months, the landlord can say 7 days before the end of that month, hey, I don't want you here next month. And if they do that properly, then if you're not out, they'll be able to get an eviction in court. This last bullet point is talking about how the landlord might waive this notice. So let's say that your annual lease is ending and you don't want it to. So February 28th comes and goes. I don't want to leave. And so on March 1, I'm going to offer March rent in the hopes that they just accept it and let me stay. So if I offer March rent and they accept it, then that notice of non-renewal or notice of, hey, get out is void at that point because they've accepted the rent. And by that, they're essentially creating a new tenancy with you, whether it's month to month or another annual tenancy, depends on your written lease. But in the case of an oral lease, and in most cases, it's a month to month lease. And so that you've gotten one more month, but they would have to give you a new notice if they wanted you out in April. We'll talk about that again later, but hopefully that makes sense. So that would be your defense. If the landlord accepts your rent the next month and then files to evict, then you would have a defense to the holdover action. Most landlords know that. So if you tried to offer March, they would not accept it. And then they would file. Now, keep in mind that just because they didn't accept it doesn't mean they aren't entitled to it. If you do stay beyond the lease term, even if they don't accept the rent, if you're worried about a money judgment, you're going to want to hold on to that money so that you can still at least pay for the time period that you're there. They are allowed to ask the court to grant a money judgment for the prorated amount of time that you remain in the home after the notice period expires. So breach of lease, the vast majority of cases that we see for breach of lease are actually non-payment cases, but they're different than box one non-payment cases because, like I said, for box one, it's all about the money. They want the money. They're taking you to court for non-payment. For box three, even though you have not paid your rent, if that's the reason, they're not taking you to court for non-payment. They're actually taking you to court for breach of lease for non-payment. And what that means is you have a written lease, like I talked about, and a written lease like I do, that says, basically, if you're 1 day late past the 5th, we can file an eviction without any notice and demand possession, regardless of whether or not you have money. It's brutal, but it's worked into a lot of form leases. So just be aware, like if February's here and it's whatever today is, the 18th, that I haven't paid, they can file an eviction without telling me they're going to, without making a demand for payment. They can file an eviction for that. And like I said, most non-payment cases are brought as breach of lease. So that means even if you come up with the money, even if you come up with money and future rent to offer them, they do not have to accept it because you've breached the lease. They are not required to waive that breach and let you stay. The breach for non-payment, I mean, the breach box that the arrow is pointing to here is going to say breach of lease for non-payment typically. Sometimes it'll say how much it is, sometimes it won't. They don't really have to, because all they really have to prove for these cases is that you missed a rent payment, that it's still gone, it still hasn't been paid, and that you're still living there. And that is all they have to prove. And so there's not a lot of defenses to box 3 breach of lease. So it would be, I would encourage you to keep in touch with your landlord property manager about that. Just because they don't have to accept it doesn't mean that they won't. So, it doesn't mean you got to give up, but definitely stay in touch with the landlord if your intention is to pay and stay. Now, of course, a breach could be something else. It could be for an unauthorized occupant. It could be for unauthorized pet, destroying the property, whatever. It could be lots of different things, but the thing to remember is that it has to be in the lease for it to be a breach. So if I have a verbal or oral lease with a landlord, and I have a dog, and the landlord finds out I have a dog and says, "Wait, I don't allow dogs. I'm gonna take you to court for breach of lease for having a dog." Well, he or she is gonna have to prove that my having a dog is actually breaching a lease, and if I don't have a written lease, then it's not breaching anything. So if the landlord is alleging that you breached the lease, your first thing, again, go to that lease. It's got to say that they're entitled to possession for that particular activity. So let's say that you have a written lease, and let's say that you got behind in your utilities, but it doesn't say anywhere in the written lease that is a breach. If the landlord says, well, takes you to court, checks that box 3 and says, well, you didn't pay your utilities, so I'm evicting you, you can say, well, where in the lease does it say you're allowed to evict me for that? Now, obviously it's still owed. They might be able to take you to court for money owed. They might be able to put something, a balance on your ledger for something. All of that is very possible, especially if it's damages or something. They could say, you clogged the toilet, I'm putting this amount on your ledger or whatever. But to actually get possession of the property back, you have to breach a term of the lease that's in writing. And the other thing to keep in mind is if you look at that lease and it has what we call a cure period, which it says like if you know, especially for like an unauthorized pet, if it says, if you have an unauthorized pet, we give you notice. A lot of them will say like 5 days, and that pet wasn't gotten rid of after 5 days notice, then we can evict for possession. We see those cases sometimes too. And of course, the first question is, well, did they give you that notice? Like, did they say, look, we saw a dog, we know there's a dog, and you know, you've got to get rid of it in 5 days. So let's say that you're like, ah, crap. Okay, so you get rid of it, and then what if they don't even check and they file? Well, again, that lease says what they have to do. They have to give you a 5 day period, 5 day cure period. If you cure it, they have to ask you and find out if you cured it. And if you did get rid of the dog, then you've cured that breach. So again, this is all going to be written in your lease. If they are required to give you a chance to fix the problem, it might be in there, and they have to follow that procedure that's in that written lease. Those are the most common examples of breach. Criminal activity, it's different than the other three in that it calls for an expedited eviction. So they can get an eviction quicker for criminal activity for fairly obvious reasons. This usually comes up, for us, it comes up a lot of times in subsidized housing cases because usually a tenant is, if they're being evicted for criminal activity, and if we get the case, we try to figure out if there's any way to preserve this tenancy. And usually that the situation would be where the tenant is not the one committing the criminal activity. It might be someone else that's on the lease. It might be a guest. But if it's not, if the client, our client, is not the offending party, we will sometimes try to negotiate a partial eviction, which is I'm okay with the offending person being evicted, banned, whatever, but I would like to stay because I'm not the one doing it. Sometimes we try to do that. In general, one leaseholder is responsible for all leaseholders' criminal activity. So if this is not subsidized, it's private landlord tenant, you have a roommate and your roommate is committing crimes. I pick a crime, I don't know, committing crimes. And the landlord finds out and files to evict for criminal activity. You are all liable for each other's behavior in that sense that you have all signed the lease that you're saying you're not going to do that. But again, a partial eviction is not just for subsidized housing, to my knowledge anyway. And it would be something you could try to work out. And the same thing goes with the financial obligation as well, while we're talking about it. If you have a roommate, you guys both sign a lease for a place, that roommate, moves out, you are responsible for the full rent, regardless of whether or not your roommate promised to pay for half. So just be careful who you sign a lease with. So anyway, back to criminal activity. A conditional eviction, again, this is mostly for subsidized, is where a person has been banned from the property, and the client or tenant allows the guest to return. Essentially, it's kind of like they get another chance to make sure that this banned person does not return with any invitation. And if they return uninvited, that the tenant immediately notifies law enforcement or whatever. It's essentially agreement to say, look, I promise not to let this person back on the property, and if I don't, then I'm allowed to stay. Criminal activity must be described in the complaint. You do not have to have been convicted of it. You don't even have to have been charged for this alleged criminal activity, but the landlord obviously has the burden of proving that what you're doing is a crime, not just bad or frowned upon, but an actual crime. Even if you have not been charged, even if you have not been convicted, their burden of proof is a lot lower than in criminal court, so it's not going to be beyond a reasonable doubt. So a lot of times when we get those cases, it's really like he said, she said, did this actually happen? And yeah, so it's not tied to the criminal court system necessarily. Okay, common defenses to an eviction. Retaliatory evictions are really, really tough one. A lot of people think landlord is retaliating when they file an eviction, and that might be the case, but they do have a lot of defenses to a retaliatory eviction. So a defense to the defense that I'm not going to get into. But if you are behind in rent or withheld rent in protest, and they file, that's not going to be retaliatory. If they have any other valid reason to evict, then a retaliatory eviction is not going to be a defense. And if you guys want more to learn more about retaliatory eviction, I can talk more at length about it. Victim of domestic violence, this is also a pretty narrow defense. If you are the victim of a domestic violence and the landlord is evicting you because of the domestic violence incident and you are the victim, you have a defense under a North Carolina statute. But if you are the victim of domestic violence, the offender is kicked out of the home or leaves the home or whatever, per 50B, you're still required to pay all of the rent, even if the offender's not there. So a lot of folks will think that because they're the victim of domestic violence, that they can't be evicted for non-payment of rent or any other reason. Unfortunately, that's not true. The landlord is still entitled to demand the rent from the remaining tenant, even if that person is a domestic violence victim. Waiver, we talked about that briefly. A lot of times, if you have breached the lease, and the landlord accepts the rent after that, you might have an argument to say, look, he's waived his right to evict me because he accepted my rent when he knew about this unauthorized pet, for example. If you have like a really sketchy lease or no lease at all, then that's a really solid defense. If you want to stay, try to pay that rent, even if you're in breach. The issue to keep in mind, of course, is your lease. Look at your lease, because there might be something in there that says any acceptance of rent by the landlord with knowledge of the breach is not considered a waiver of their right to possession. So they could write into that lease that says, I can still accept rent even though I know this lease is being violated in this way. Not valid against an eviction based on criminal activity or failure to pay if money is still owed. And the anti-waiver clause is what I was talking about, the language in the lease. So invalid notice, that is probably the most common defense that we have, because a lot of landlords do not either don't care to learn landlord-tenant law, or I don't know, but a lot of times their notices are just way off the mark. Maybe it gives the wrong amount of rent. I mean, if it's a box one, maybe it gives the wrong amount of rent owed. Maybe it doesn't give you enough time. Maybe it was supposed to be in writing and they only told you verbally. Or maybe they say, okay, I want you out by February 15th when your lease doesn't end until February 28th. They've got to not renew or terminate the lease at the end of a lease term. They can't do it until it is the end of that lease term, whether it's month to month, it's the end of the month, or year to year, it's the end of the year. Failure to offer a reasonable accommodation. So we do have fair housing laws, federal and state fair housing laws, that allow a person with a disability to request what's called a reasonable accommodation, which basically just says, this is my disability, or I have a disability. Here is a letter from my doctor explaining why this particular accommodation I'm asking for is necessary for me to be able to enjoy my tenancy like a non-disabled person would. Emotional support animals is a good example of that. So if you have, we could do a whole separate presentation on fair housing laws, but if you have an ESA and you have the proper documentation and you submitted it to the landlord, and the landlord turns around and tries to evict you for having a dog, that's a big no-no. You should call us if that happens. And that way it would be a defense. But there's lots of different types of reasonable accommodations. Again, you can call legal aid if you have a question about that. Amount claimed is wrong. I mentioned that. Failure to make a demand for possession before filing lawsuit. I do not like this defense. But technically, even for a breach, box 3, where I said they didn't have to give you any notice, the law does, or the complaint they sign when they file the eviction says that they asked for possession and you didn't vacate. So some jurisdictions that will work to say, look, I'm behind in my rent, but they didn't actually ask me to leave before they filed this. You might get it dismissed based on that, but I would not count on it. And then the criminal activity, if you really had no reason to know what was going on in terms of the criminal activity, you did everything you could have reasonably been expected to do to prevent it, stop it, report it, whatever. If you're really just like an innocent party in the situation, that's when you could possibly get a partial eviction. You would have, obviously a right to raise that defense in that situation. Unfair and deceptive trade practice. For our purposes, what we mean by this is that a lot of landlords will put improper fees on their ledger. So a lot of things we ask for, we want to see that ledger pretty quickly, because especially unsophisticated landlords might say something like, okay, I'm charging you $5 a day for every day that you're late. Or I'm charging you an administration fee of $70 a month that is not written in your lease. You have no idea what it is. Or some bogus fee that's, again, look in the lease. If it's written in the lease, then they're probably allowed to charge it. But late fees are governed by North Carolina law. So they can only be 5% of your monthly rent. So if your rent is $1,000 and they're charging you a $500 late fee, that is an illegal late fee. And if they charge it to you, or if it's in the lease, then the entire lease term regarding late fees is stricken. So essentially you would have no late fees provision in that. But in the event that they put it on your ledger, they put it in the complaint, unfair and deceptive trade practice is not so much a defense as it is a potential counterclaim. Because when they do that, there's the statute says that you may be entitled to fees or fines for what they did. So depending on how much you're behind, that could balance out in terms of who owes who what. So look at your ledger. If there's something on there, and this doesn't include court fees, of course, if they've already filed. If they charge you court fees and they haven't filed yet, then that would be an illegal fee. So always ask for a ledger, because there may be something on there that's illegal, and then you've got some leverage all of a sudden. All right. Things to remember at the hearing, as I said, be on time or be there early. There's no rule that says you can't say, hey, property manager, this is what's going on. Can we agree for a continuance? Can we agree for whatever? I mean, whatever. It doesn't hurt to try to negotiate. Face mask may be required. The evidence that you want to bring, so many times I hear tenants say, well, it's in my car, or I didn't bring it, which is always baffling to me. Because that's the one time you should bring it. And don't count on bringing everything in on your phone, because sometimes phones are not allowed. It can be stressful or difficult to get permission to bring your phone in. And it can also delay the hearing and make the magistrate mad. So we always recommend printing out what you've got. If you've got screenshots, obviously receipts, you want to bring those in. Anything to prove what it is that you are trying to prove, you're going to want to bring it, and you're going to want to bring 3 copies, because ideally 1 copy for you, 1 copy for your landlord, and 1 copy for the magistrate. Everybody's looking at the same thing at the same time. Magistrates appreciate well-organized presentation. You want to get on the magistrate's good side, period. You just do, because it always helps. So being organized, detailed, all of that is going to definitely help you out. Just circling back to the box 3 for breach of non-payment real quick, a lot of people will, and you have a right, of course, I said to a hearing, you have a right to explain why you got behind in your rent. Whether it be medical issues, a death in the family, a lost job, whatever it is, they are obviously very valid reasons for why you got behind in your rent through no fault of your own. That being said, it's likely that the magistrate's going to say, I understand that, and that's awful, but I'm not even allowed to consider that as a defense. While it may be understandable, the magistrate simply does not have the authority to say, oh, well, that's understandable. I'm going to go ahead and just let her stay because this is happening in her life. That being said, you absolutely can give an explanation if you want to, especially if you want to ask for a continuance. If it's your first time on and something's been going on, but you think you can resolve the issue, you think you can come up with the money, or you're moving out like the next day or something, You can always ask for a continuance for what we call compliance, which is to get everything back in order. And I would recommend asking the plaintiff beforehand if they would agree to that, if that's what you're trying to do. Again, the magistrate's going to want to hear who's being the most reasonable, who's trying the hardest, right? So stay in touch. Just because you don't have a defense doesn't mean that you can't get a little bit more time to either move out or pay if you ask. So if you're in a situation where they're accusing you of doing something you didn't do, obviously the documentary evidence is important, but you can also bring witnesses. For example, if someone, I had a few cases where a tenant was being accused of having an animal, or like a cat or whatever, and the client was actually really, really allergic to cats. So one of the tenant's, pieces of evidence in their defense was to bring their mom. It was like, my kid has been allergic to cats since they were little. When they get around a cat, their face explodes and blah, blah, blah. And like, there's no way that she has a cat. Or, anyone with direct knowledge. You can't, if you bring someone that's like, oh, she's a good person, that's not going to be relevant and that's not going to be heard. But if it's actually what the case is about and someone, a friend or family member or maintenance person or whatever, has direct knowledge of what you're talking about, then they can testify. Like, I saw this on this day, or, whatever, as long as they have direct knowledge, meaning they saw it for themselves and didn't hear it from somebody else. So along the same lines, if a landlord tries to say, well, I'm evicting this person because a neighbor told me that they did this, that's not allowed. That's hearsay. Neither party's allowed to introduce hearsay evidence. So if the only evidence that the landlord has is what somebody told them, the landlord doesn't know themselves, the landlord never saw the dog themselves, landlord didn't see the fight, the landlord is just going by what they were told, then you can object to that. You just say objection. That's hearsay. And just keep in mind that you have a right to question or cross-examine the person that's making these allegations. And that's why hearsay is not allowed, because if the neighbor can say all this stuff and you have no right to cross-examine them and ask them questions about what they're saying, then that's an issue. So that I would say for police reports, police officers and police reports, that's not quite as strong. A lot of times magistrates will allow hearsay evidence and through police reports, but call us if you are being accused of something that you did not do and you want an attorney, and if you qualify for our services otherwise, we can look into it. Tenants should end by saying what they want the magistrate to do. This is really important because it's not always clear to a magistrate what the tenant is asking for. And like I said before, you can ask for continuance, and that you're going to want to do at the beginning. Before you get into any evidence, you're going to want to do that at the beginning. If the continuance is granted, you'll get a new court date. You won't get into the facts. But for the most part, if you do have a defense and you raise the defense and you had a hearing, at the end of your testimony or in the closing arguments, if the magistrate allows those, you say, I want it dismissed. I want it dismissed. That's what you're going to say. Or, if you don't have a defense, you say, Your Honor, I want an opportunity to do this or whatever it is. I would recommend going in there with a plan to solve the problem. Or if you just outright deny it, then be sure to say, I want this dismissed. They have not met their burden of proof and I want this dismissed. Along the same lines, if the landlord is there, doesn't have any direct knowledge of whatever the alleged breach is, but they ask you, isn't it true that you've had a dog for the last 6 months? And you say yes, then they're going to get you that way. But all right, so magistrates typically rule immediately, but it can take 5 business days. Yeah, the vast majority of decisions are made on the spot. But if it's a complex situation, it's possible that the judge or the magistrate will say, look, I'm going to mail my decision. It's really important because your appeal period, depending on when your appeal period expires, it's going to be really important for the day that judgment was entered. So just call the clerk if you're not sure, if you're trying to appeal something. So again, assuming that the judgment is entered on the day of court, both parties have 10 days to appeal a decision if they lost. So you don't have to have had a defense, although there are potentially financial consequences for appealing when you did not raise a defense. But Um, it's written into the law that you have 10 calendar days to appeal. So nothing can happen in those 10 days. Nothing, they can't, there's no legal eviction, at least, that can happen within those 10 days. Um, so if you lost the hearing, and you want to file an appeal within those 10 days, you're going to go to your clerk's office. The appeals typically require a filing fee of $150. And if it's for non-payment of rent, then the clerk is required to demand that you pay all of the back rent owed while on appeal, which of course for most people is not going to work because that's why they're there to begin with. But if you get food stamps, if you get SSI or otherwise qualify by filling out the affidavit of indigency, then the $150 filing fee is waived and the back rent for the time does not have to be paid to the clerk's office. If you are planning on appealing and you are planning on paying and staying after the judgment is entered, the pay is going to go to the clerk, not the landlord. At that point, the clerk is going to take your appeal paperwork. They're going to tell you how much rent bond is what that's called. It's a bond to stay the execution of the padlocking, which is why it's called a bond. The clerk is going to say, okay, well, you've got a bond this much for this month, and then next month, your rent's got to be paid to me, right? Meaning the clerk. So if your rent's $1,000, your court date was halfway through the month, it's prorated from the court date. So if your court date was halfway through the month, when you appeal within the 10 days, they're going to require the second half of that month to be paid on appeal at the same time. And then next month, while your appeal is pending, while you're waiting for a new court date, basically, in order to stay while you're waiting, you would have to pay $1,000 to the clerk. Due on the 1st, late on the 5th. The clerk will tell you the exact day, but I always say due on the 1st, late on the 5th, as if the clerk was your landlord. You've got to get there. If you do not get there in time, and the landlord gets there first after the 5th day, they can request a writ of possession for your failure to not pay the rent bond. Once that happens, there's no undoing it. If a writ of possession is properly granted, then even if your appeal is essentially pending, or your appeal would still be pending, but you would get padlocked from the home. So the appeal is not going to help you all that much if you're looking to stay there on appeal. So just make sure you get that rent bond payment in each month if you do not want to be padlocked. So again, the appeal is it's to district court. So from small claims court to district court, it's a higher level, it's more formal. De novo means that it's a new hearing date. What happened in small claims court it's like it never happened. And you get basically another shot in district court. I will say it's not totally like it never happened, because if your landlord says one thing in small claims court and this is something else in district court, then that's gonna be an issue for them. So in that way, their testimony in small claims court is important, but the judge's decision is wiped out, or the magistrate's decision is wiped out, and you're awaiting a new court date. And I mean, it makes sense if the small claims magistrate gets it wrong on the law, which they do, and you say, you're wrong. I want another court date with a higher judge. You're entitled to ask for that. And as long as you pay your bond on appeal, you will stay in your home until you have another hearing. Sometimes, depending on where you are in North Carolina, sometimes the court date is given to you when you appeal. This would be like a smaller jurisdictions. And it's more rare, I would say. Most of the time, when you file the appeal, they say, okay, we're going to notify you by mail at the address when your court date is. If you do move out during the appeal, but you still want that next hearing, you need to make sure that the clerk has your current address so they can notify you by mail of the court hearing. So, you could still be heard on your appeal even if you're not in the home anymore. So the writ of possession, like I said before, the clerk grants it, and then basically tells the sheriff, okay, you can call the landlord and schedule this padlocking. When that happens is all over the place. I would say it's usually within 5 to 7 days after the writ is issued. And if you are not sure whether a writ is issued, you can call the clerk's office, give them your case number, that number on the top right of your court documents, 25 CVM something. They'll be able to pull it up by far the easiest that way. So always have that with you. If the clerk says yes, the writ of possession has been issued, but they're not going to have the information of when it's going to be executed, meaning when the padlock's going to happen. The sheriff's department would have that information. This, like the service of process folks. You call them, they should be able to say, yeah, it looks like we're going to be out there on what such and such day. The sheriff almost always posts the writ of possession on your door before the actual padlocking. We hear sometimes that it doesn't happen, which is why I can't say always, but they are supposed to. So if you miss your rent bond and you come home and you see the writ of possession on your door, it will have a day and time of the actual padlocking of when they'll come back. There's no continuance of it. There's no your chances of getting it overturned are extremely slim. So I just typically encourage folks to try to get everything out by that padlocking day. And just even if you swear that everything is unfair or not been done correctly, you can certainly call us and we can check it. But it's kind of an unforgiving process once the writ of possession is issued. I think this is basically what I've talked about already. So the second part of this slide, technically, North Carolina law says that the landlord must acknowledge and allow a request from a tenant within 7 days from the padlocking to go back in and get the rest of their belongings. If the remaining belongings are worth $500 or less, they only have to give 5 days. Obviously, like, how do you even say whether it's $500 or less or more? Like, this is not a process that the judges are like watching over, right, to make sure everybody follows the rules. And I say that because a landlord, really, all the landlord has to do is acknowledge and let you in to the property one time at the lease. It doesn't say how long, and it doesn't say how many times. So I discourage clients from counting on that. Like, oh, well, I wasn't able to stop the padlocking, so I'm going to use those 7 days to get the rest of my stuff, because the landlord has possession back at that point. You cannot be on the property without their permission. And if they're hard to get in touch with, or they're like, sure, I'll let you in there on the day and time that you requested, but only for this amount of time or whatever. It's very, very hard to enforce this rule. So I would encourage you to get everything out. That being said, I did talk to a landlord attorney the other day, and or a landlord, actually, Andy's an attorney, but he said that the vast majority of the time he does let people back in there because it's easier for you to clean out the house than for them to have to do it for you. But make sure you've got anything of value out of there, because it would be scary not to be able to see it again. This is our chart, our legal process of eviction chart. So that's just what I've already said in chart form. Yeah, we covered all that. All right, the implied warranty of habitability. Landlords have a duty to keep their units in a fit and habitable condition. Fit and habitable is, it's going to be defined in North Carolina state law, and the majority of the time it's also going to be defined in your city or town's local minimum housing code ordinance, which is enforced at the local level as well. Some teeny places do not have a minimum housing code. Trying to think of an example of a tiny town that doesn't have one. But anyway, chances are where you are, there is a minimum housing code, and there is a minimum housing code enforcement department as well that has inspectors that will determine whether or not the landlord has kept up the place as they're supposed to. So that's what I said, the local housing code. Repair dangerous conditions in a reasonable time. We'll talk about that in a minute. Common areas have to be kept safe, and then essential things, electrical, plumbing, heating and air, and other facilities facilities and appliances have to be maintained in good and safe working order. And then smoke and carbon monoxide detectors obviously have to be there. These duties cannot be waived or avoided by the landlord. If your landlord says, okay, this lease says that you're responsible for all repairs, that is not going to be enforceable. That's illegal. It's not going to work. They're the landlord. They have the responsibility. They own the house. They really are the only ones that have the authority to do anything to the house, or should have the authority. So if a landlord's saying that, that's a huge red flag, and I would run far away from that landlord. The other thing you've got to remember is that you have to keep paying your rent, even if it is uninhabitable, even if the inspector found that it did not meet the minimum housing code. And I'll talk more about that specifically in a second. But in North Carolina, you cannot unilaterally withhold rent because of conditions. This is irritating for lots of reasons, mainly because most of the time, that's the only way a tenant can get a slumlord to pay attention. Uh, but that's why legal aid is here. So if that's the situation, if you withheld rent and you're being taken to court and your place is a slum, call us, please. We're experts at that. But obviously you might have a defense to that, but you don't have an automatic defense to it just because, oh, well, the place is crap. Look at it. They can still get possession just because if you did not pay rent, that's what they're bringing you to court for. Now your defense is something called rent abatement. So if the landlord breaches the implied warranty of habitability, as it's called, whether you have an inspection or not, the court can decide, even without an inspection, based on the evidence, whether or not the landlord has breached that duty to maintain the house. And essentially, you are counterclaiming for rent abatement or rent refund. Rent refund just makes more sense. To the extent that it's past rent, but they can abate the rent into the future as well if the place is still in bad shape. So essentially what this looks like is if you have a lease and you pay $1,000 a month for a 1-bedroom, and let's say it's infested with roaches, not because of you, but because there's a leak somewhere and you've got those water roaches all over the place, or you've got, a leak somewhere and there's mold growing all over the place. Whoever's listening can probably come up with lots of examples of reasons why the home may not be worth $1,000 in the condition that it is. So essentially what you're saying is, while the contract rent or the lease says $1,000, if you look at all of my evidence, you think that this would be a fair market value. You think somebody would be willing to pay $1,000 for this in this condition that it is right now. That's what you're saying. And if you've got an inspection, we usually encourage folks to call code enforcement because it's an objective opinion that is very heavily considered by the magistrate. That being said, some places are so bad that code is going to say, I can't let you live here. This is unsafe. That's called condemning the property. Condemning, just because a code enforcement case was open doesn't mean that the house has been condemned. Some of the paperwork says it has been, which is confusing. But the easiest way to remember if it's been actually condemned is it's usually a 48-hour condemnation notice. It's a big yellow or orange piece of paper that says it is illegal to be here. And what that also says is the landlord is given basically 48 hours to fix the issue that is so bad that it's unsafe for you to even be in the home. So this would be electrical stuff that, could cause a fire, no heat in the winter when it is very cold outside. I'm not going to go into the specifics of that, but like tomorrow, for example, if you do not have heat through no fault of your own, and you were to call the code enforcement office, they would I don't know. A lot of times they're nice and they don't kick you out if you have space heaters or something where you can keep it heated yourself. But or if there's no running water, that would be another one. Those are your house could be condemned and you could be told to leave. Of course, you've got a great defense to a non-payment case if that happens, but it's not really doing you much good when you have nowhere to live for the time being. So when the words rent abatement do make sense, as we were talking about in the future. So if you're saying, look, my $1,000 apartment is only worth $200 because of all these roaches, it smells terrible because there's mold and there's this wet spot in the floor and my foot's about to go through it, or, there's a hole in the wall. We could tell you some stories. We really could from legal aid, but I'm not going to get into that because I don't have time. But what you're going to do is you're going to go into court and you're going to say, you need to file a counterclaim, but the legal argument is going to be my place is not worth $1,000. I think, and yes, you can give your opinion that it's only worth $200. Or if it's bad enough, you can say you think it's worth $0. For example, if you are if you have a moisture issue, I'm not going to say mold because code enforcement does not make decisions on mold. They do not record anything about mold. They're not allowed to. It's not in the minimum housing code. What they do look for are leaks, plumbing issues, moisture issues, they call them sanitary issues. So while they may see the mold is there because there's something else. There's a leak, there's something else going on. And that's a lot harder to see, obviously, because it's behind the walls. But if it smells bad, if you have, pictures showing all that, your personal belongings are covered in like that white, whatever, arguably the value of the home is zero because you can't even use it as a storage unit because all your stuff's getting gross. Keep in mind though, the longer you stay in a unit that you are describing as uninhabitable, the less sympathy you're going to get from the judge because the judge is going to be like, why are you still there? Even if you haven't had anywhere to go for lots of valid reasons, it's something that can cause difficulty. The important thing to remember is that most of the time, the magistrate is not going to let you talk about conditions unless you actually file a counterclaim. And fortunately, if you're doing it on your own, really all the counterclaim has to have on it is the party's names and the case number. And then you can handwrite it out. It does not have to be formal. You do have to mail a copy to the landlord, and on the complaint is all the information. This is a counterclaim, meaning it is counter to a claim that has already been filed. So that complaint, and that is going to have everybody's addresses, everything that you need to file this counterclaim. And if it's not filed, the magistrate may say, look, that issue has not been brought before me. There's nothing filed before me on that issue, so I'm not even gonna let you talk about it. So better safe than sorry. And they're also not allowed to grant you any money if you're asking for money back unless you filed something. So there is a filing fee, but if you can qualify as indigent, and always bring this up to the clerk, they don't bring it up automatically. Especially when you appeal, they won't. They'll be like, you got to pay all this. Remember, you may not have to if you qualify as indigent. And if you have food stamps, make sure you bring proof of that and your photo ID to appeal or to file an indigency petition for a counterclaim. You put in that counterclaim, these things. I've lived here this long. This is what I pay. These are the issues. I told the landlord about these issues at this time. It's been months. You got to give them a reasonable amount of time. But it's been months since the landlord or he hasn't done anything and This is very, very evidence heavy. Pictures, recordings, witnesses. Bring in a witness that says, I can't even walk into that apartment because it makes you want to gag. Because usually, I say this because usually it's a smell associated with it, moisture and stuff like that. Witnesses, all that. So if you've presented all that, and what you're asking for is a rent abatement. Say, Your Honor, I am asking that my rent obligation from the past be reduced by this amount. So if you're saying it's worth $200, then you're going to ask a rent abatement of $800 per month for the rent that you have paid. It's possible that the numbers work out to where they zero each other out. The landlord says, look, doing the numbers here, she doesn't actually owe you anything because I've determined that the rent should be $200. So at the same time, though, if you're saying that's uninhabitable, magistrate is going to encourage you to take advantage of that decision to move out. But it could reduce the rental obligation. Then of course, going forward, if you're in court and it's still like it is there, you can say, and I also, judge, and you can call them judge, you don't have to call them magistrate. Judge, I would like you to write in your decision that my rent going forward is only $200 until these issues are fixed. Depending where you are in the state, some might do that, some might not. But that's what you're asking for. It's really a numbers game, and it's really just your opinion based on the evidence that you have and your experience renting places in the town that you are. If you are in one of those jurisdictions where they don't require you to file a counterclaim to talk about it, you can always try. You can't be awarded any money from the landlord, but it's possible that you could zero it out just defensively by saying, look, same math, let's say the same math. Like, look, I'm not asking for any money, but I'm asking that you take what I'm saying and determine that the math works out, that I'm not behind in my rent. because of all of this, and get the case dismissed at that point. But you should still move out because chances are that landlord's not going to make those repairs. In all of my time here, I think landlords made repairs, adequate repairs, maybe once or twice. I don't have a great record of that. Okay, so we talked about this code inspection report. Code inspectors are, for the most part, they're pretty great. Individual code inspectors, I don't know, but inspection reports, if they've opened a case, it's going to have valuable information in there. And typically it has its own pictures as well. You can subpoena the code inspector to be there. You can ask nicely for the code inspector to be there. But even if they're not, magistrates almost always and should let in those reports without the actual inspector being there. And you can introduce it as an exhibit. And that's really kind of the only witness that's there that doesn't have to be there in person. Now, if for some reason the magistrate's saying, you need the code inspector here, then you need to request a continuance to have them brought in. But they don't usually do that because for pro se, meaning people without attorneys, it's difficult to do. Your testimony is extremely important in this case, and the details of it are extremely important because it's really going to be the landlord's going to almost certainly say a few things. Well, they never told me about it. They caused this problem. I fixed it and they messed up my repair. What's another one? I mean, it's usually the same things they say over and over again. So be prepared for that. The more detailed you are, your timeline, I always encourage clients to have a timeline. And if you don't have like proof that you told the landlord, but if you say on February 18th at around 2:00, I called the landlord and this is what we talked about verbatim. That's going to mean a lot to the magistrate. The magistrate's going to be like, well, that's pretty detailed. But if you're like, oh yeah, I'm pretty sure I told them, sometime like, I don't know, a few months ago, that's not as good. Obviously pictures are really important, but your detailed timeline of just the grievousness of landlord's behavior or lack of attention to the issue is going to be really important. That being said, if the landlord is sending people out, is trying to diagnose the problem, it appears to be making a good faith effort, you should give them some time to do it or to fix it. And when it gets to the point where they just aren't doing it, you can file, rather than a counterclaim, you can file an affirmative, we call it affirmative, meaning you're the one that brings the initial claim, rent abatement against your landlord, which that's trickier. But you can find some information on how to do that on our website. And it's in small claims court. And I'm always happy to see tenants doing that on their own. Yeah, witnesses with firsthand knowledge, hugely helpful. So this is what I talked about, the as warranted value, which is what what you're paying for, what the landlord promised you with the lease, and the actual fair market value in the condition that it is what it would be, basically what someone would be willing to pay for it. And that's what I would say. Like we have some housing situations where rats, we have lots of rat infestations. And I would always be easy for me to say, Your Honor, how much would you pay to live in a house where, a rat may or may not run across your face while you're sleeping? Answer is probably zero. Yeah, so that's just one example. Damages are limited to the amount of rent you actually paid. So if you didn't pay rent for 6 months, the court's not going to be like, here's 6 months worth of rent. That should be fairly obvious. And it applies for subsidized programs as well. Consequential damages is another one that, like space heaters is a great example. If you don't have heat, but you have bought space heaters, or if you don't have heat through no fault of your own, and you have paid for space heaters, that means your electric bill is going to skyrocket because they are expensive to run. If you had to leave and stay in a hotel, all of the keep receipts of that. You're not going to get anything if it's just, I spent around this amount on that. No, you need to keep it. You need to have utility bills. You need to have hotel receipts. You need to have receipts for the space heaters or these type of space heaters. And this is what they sell for at Home Depot or whatever. You got to have something. Go in there with a number. Like, Your Honor, this is the amount I've spent, and here's proof. You got to be specific, or the magistrate's going to say, look, you haven't given me enough to settle on a specific number here. but you should be able to recover the cost of that because that is the landlord's responsibility. Security deposits. A lot of folks think that or don't understand that security deposits are not considered until after a tenant vacates. So, for example, a lot of tenants, if they get that notice to vacate before, and there's like 1 month left on their lease, and they're like, oh, well, I'm not going to pay rent because my landlord has my security deposit, so I don't have to pay rent. Um, that does not work. You still could be taken to court for non-payment of rent, and just an eviction filing in and of itself is really problematic. So if there's anything you can do to avoid that, you should, even if you can get it dismissed. And for that reason, you really need to continue paying your rent, even if there's a security deposit there, because the security deposit is meant for other things. So if there was damage and the landlord has to pay to fix something, they can take that out of security deposit. If you're more than 1 month behind, then obviously 1 month rent is not going to cover that. So you just really should pretend like it's not there during your tenancy. And then you can be like, yeah, I got it back. But the law, NC Security Deposit Act law, says that the landlord has to, within 30 days after you turn in your keys, either return your deposit or give you an accounting of what they're going to do with it. They have to give you at least an interim accounting within 30 days, and they have to finalize that within 60. Normal wear and tear cannot be deducted. There's all kinds of arguments over what's normal wear and tear. Honestly, they could be litigated probably all the time, but if you dispute what the landlord is saying about your security deposit, you can take them to small claims court. If they don't give you any information at all in 30 days, then the law says you're entitled to security deposit back regardless because they did not follow the rule. And you can take them to court for that as well, small claims court. And the easiest way to do this on your own is you go to the NC Court's website, there'll be forms there. Anything that says magistrate summons, complaint for money owed, but those forms are for small claims court, and that's where you're going to want to take this. And I encourage you to do it. If the landlord has messed up this particular part of the process, then I would encourage you to take them to court for it. You do have to serve them legally, which is tricky. But again, check out our website for information on that. They are supposed to hold the security deposit in a bank. If the landlord sues in small claims courts, need a money judgment. Okay, yeah. So if the landlord did get a money judgment for you and your security deposit does cover it, then they should apply your security deposit and file satisfaction of that money judgment. You'll have to check with the clerk's office to make sure they did that. I would encourage you that if you owe the landlord money but you didn't get your security deposit back and you're like, well, you violated the statute, they could counterclaim on your claim and say, all right, well, they're entitled to the security deposit back, but they owe me $6,000 in rent, so I'm asking for a money judgment against them. So sometimes you can bring a problem on by doing that. Yeah, I mean, just take pictures on move out. And take pictures on move in. Honestly, when you move in, take pictures of everything, how it looked when you moved in. And then before you hand in your keys, take pictures of everything so they can't say you trashed it if you did not. All right. I think that's everything I was going to talk about.
All right, we are now going to open it up for our question and answer session. Again, if you have any questions, you either need to type them in the Q&A box on Zoom or put them in the comments section on Facebook. We do have one of our attorneys here with legal aid to answer those for you. The first question I'm seeing here is someone is asking, can a landlord charge legal fees for filing an eviction on the basis of unpaid rent if the tenant got caught up on that rent before the eviction was filed? So can a landlord charge fees in that situation?
So the statute that governs fees, including legal fees, but all kinds of fees, is North Carolina General Statutes 42-46. And if the landlord never filed, but let's say the landlord like consulted with an attorney, then no, that's not permissible under 4246. But if the landlord files an action and then dismisses the case, there's a few different scenarios in 4246 that outline when they can charge legal fees. There are times when they can. Yeah. There was recently a change to this statute and the charging of legal fees. Um, but I still think that the landlord has to initiate an action.
Perfect. Can a landlord evict a tenant on claims that aren't stated in the lease? So I think this question is asking, can a landlord file on the base, I'm assuming on the basis of breach for something that's not considered a breach under the lease?
So there are only four grounds that a landlord can base an eviction action on: non-payment of rent, the tenant staying past expiration of the lease, that's also known as holdover. Um, Breach of the lease, that has to be specifically specified in the lease. If, for example, the landlord wants to file an eviction because the tenant has a dog, the lease has to say that the tenant's prohibited from having a dog in order to file an eviction for breach. Or criminal activity is the fourth.
To those of you who have your hands raised, you cannot unmute in this forum. So if you have a question, you either need to type it in one of the chat boxes. Next question that I'm seeing is if a tenant is removed from the unit by a sheriff per a DVPO order, and that DVPO grants possession to someone like a landlord or grants possession to the victim, does the 50B court order sever the landlord-tenant relationship?
Okay, that's a really interesting question. I don't think I've ever seen that. Um, the 50B order probably, I mean, if a person is a defendant of a 50B and there's a 50B order that prohibits that defendant from going to a specific place, whether it's the place that the defendant lives or not, even if it's the place that the defendant lives, going to that place is considered a crime. So anybody who's the defendant of a 50B who's prohibited from going certain places, to violate any provision of the 50B is a crime. Whether like rent is still owed in that scenario, I think is a very interesting question, and I don't think there's a very clear answer to that. There are some statutes that talk about if the tenant is the victim of domestic violence and that victim of domestic violence tenant wants to get out of the lease. And that statute is 42 60 I don't remember off the top of my head. Give me one second. 4245. 4245.1. And that statute talks about ways that tenants who are victims of domestic violence that want to get out of the lease, how they can do that. Otherwise, I don't know that there's a super clear answer.
Gotcha. Next question. Someone's asking if there is a specific written document that's available which specifies what exactly is safe electrical, plumbing, and structural for a landlord's responsibilities for habitability.
That's also a good question. No, I don't believe so. The statute lists with some specificity the types of issues that, but I don't know that there's like exact definitions. Also, many cities and towns in North Carolina have local ordinances, housing code ordinances that also outline some of the things that are considered habitability issues. The most definitive place is code enforcement. Those code enforcement um, officers are um, they're certified in being able to identify what meets the definitions in the statute and in the local code. So if there's ever a question, getting a local code enforcement officer to come to the home, they'll then write up a report that will be the most detailed.
Okay, I think a follow-up, a little specific, but I think a follow-up question is essentially asking when there are things like natural disasters such as Hurricane Helene, does that change any of the electrical, plumbing, or structural kind of expectations from a landlord or a landlord's duty to fix?
It doesn't. We don't have very um, good or clear uh, laws around disaster. When disasters happen, the laws that are in place don't always really fit. And there can be a lot of confusion during that time. The only statute that applies when a disaster, um, well, there's two. One is related to disaster specifically by fire, and the other is basically just says that if the home is so destroyed by a disaster, then the tenant sort of doesn't have to, and tenant can get out of the lease. But short of that, there really isn't anything specific about that. Having said that, um, you know, judges are going to be sort of understanding if things are not working because of a disaster, and there's a lot of factors like how recent was the disaster? Has the landlord made attempts to try to resolve the issues? There will be a lot of, I think, factual considerations in that circumstance.
Like, in thinking of days to the court, such as days to pay a rate, Lord, days to pay a rent bond or days to file an appeal, is that 5 calendar days or 5 business days? Or 10 business calendar days, or just whatever the number is based on calendar or business days?
It depends. The 10-day timeline to file an appeal is 10 calendar days. And it's 10 calendar days from when the eviction in small claims court was entered in court. So usually that's going to be 10 days from the day you had your small claims court hearing. If the 10th day lands on a weekend or a holiday, then it moves to the next business day. But that's 10 calendar days. For rent bond purposes, that statute is North Carolina General Statutes 42-34. And that says that you have a tenant must pay his or her rent on the day that it's due, but will provide for a 5-day grace period. Those are also actually calendar days. Is that? true. I'm just confirming that um where the there is a little extra nuance timeline, which is that if the small claims court case is within the last 5 business days of the month, if the rent is paid monthly, that's business days, then the rent bond is not due until the next month. So that's a timeline where it's business days, but otherwise, I think usually it's calendar days. And you can always confirm with the clerk if there's any question um about when something is due.
Perfect. Next question. Um, in a situation, hold on, let me see how I can ask this. Um, a situation where a landlord is not applying a timely rental payment because of disputes regarding other fees. What is the tenant's kind of option there? Like they're paying their rent on time, but it's not being applied because this tenant hasn't paid other fees that the tenant disputes are proper.
Mhm. Um, I mean, that's also kind of a legal gray area. And if a tenant is concerned that a landlord is charging them illegal fees, then I would advise that tenant to reach out to legal aid. It's illegal for a landlord to charge illegal fees. It's considered an unfair debt collection, and the landlord can be subject to civil penalties. Um, but if if a I guess the best thing is for a tenant to keep receipts of all the money that they pay, be clear if they're paying via check or or electronically, to be clear in some kind of memo line what the money is for. If the tenant is behind, let's say the tenant is behind January rent, and then the tenant goes to pay rent in February. Most leases will allow the landlord to take the money in February, apply it to January, and still evict the tenant for non-payment of February. Um, that's if the tenant is behind on their actual rent. But if there's a, you know, dispute about other types of fees, I think that the tenant, if they continue to pay rent, needs to be clear that that's what they're paying. And you want to, the lease will govern, the lease plus ch chapter 42-46 will govern what types of fees landlords can and can't charge.
Okay. And this is the last question that I'm seeing. Might not be able to answer this, but it sounds like it's an eviction case where at the district court level there was a consent order and the other party, the landlord, is violating that consent order. Don't what would the options be there if you have anything to say to that?
If you are a tenant who had a lawyer that negotiated the consent order, you should consult the lawyer. Um,
Perfect. I actually think
it,
that's a good place to stop. Given the
yeah,
question, I think that's a perfect place to stop. Oh wait, does the landlord have to provide parking for vehicles?
there's no statutory uh obligation for that, though that's the type of thing that would be found in the lease.
Perfection. Um, and to those of you asking about assistance with legal aid, we do we have had some cuts to our funding and cuts to our staff, so we cannot open a case for everything. So please just keep that in mind. You are always welcome to give us a call. during, I believe it's from 8:30 to 4, Monday through Friday to see if you qualify for services. But please keep in mind that we cannot open every case given limited staff and limited funding. Okay. As I am not seeing, also Legal Aid of North Carolina does not help landlords evict tenants. Seems questions about that. Perfect. Okay. As I have not seen any more questions, I'm going to go ahead and say thank you to all of you for joining us, with a special thank you to Holly for answering those questions. If you would like to review anything that was discussed today, a recording of today's event will be immediately available on our Facebook page to be, okay, yeah, will be immediately available on Facebook page to watch at any time with or without a Facebook account. If you would like to register for one of our other listen and learn programs, such as Simple Divorce, Child Custody, Fair Housing, you can do so on our website at www.legalaidnc.org/clinics. Thank you all so much and hope everyone has a wonderful rest of their day. Yeah.